Ready? Start. We are in respectful agreement with Balkrishna Iyer J when he stated that the word Hindu should be accorded the same significance in relation to both religious and charitable endowments as construing the scope of the Act and its provisions. The principle laid down by the learned judge that a religious institution like a temple would not be a Hindu religious institution or a Hindu religious endowment unless it was exclusively Hindu in character, was approved of by a division bench with reference to a temple for Hindu religious and charitable endowments, Madras. He expressed his agreement with the test of exclusiveness at pages 370 to 371 of the report, and the judge expressed his agreement with the test formulated by Balakrishna Iyer J at page 378 of the report. That decision of a division bench is authority binding on us. Even had we been convinced that the test of exclusiveness formulated by Balkrishna Iyer J with reference to both Hindu charitable endowments and Hindu religious endowments was not correct, we could only have referred the question for determination by a full bench, as the determination of that question necessarily involves an examination of the correctness of the decision of the division bench for Hindu religious and charitable endowments, Madras, which accepted that test as correct. We are not convinced that that decision requires reconsideration, full bench. Normally, that should have sufficed to reject this appeal. We shall, however, examine the question at issue as if it were res integra. Was the test of exclusiveness formulated and applied by Balkrishna Iyer J correct? The Act did not define what a Hindu public charitable endowment was, nor did it define a Hindu religious endowment. The Act, however, defined a charitable endowment in Section 6(4) and a religious endowment in Section 6(14). Section 6(4) runs charitable endowment means all property given or endowed for the benefit of or used as of right by the Hindu or the Jain community or any section thereof for the support of maintenance of objects of utility to the said community or section, such as rest houses, patalsala, schools, colleges, houses for feeding the poor, and institutions for the advancement of education, medical relief, and public health, or other objects of a like nature, and includes the institution concerned. Religious endowment or endowment means all property belonging to or given or endowed for the support of mats or temples, or given or endowed for the performance of any service or charity of a public nature connected therewith, or of any other religious charity, and includes the institution concerned and also the premises thereof, but does not include gifts of property made as personal gifts to the archaka, service holder, or other employee of a religious institution temple, which itself is a religious endowment as defined by section 614 was defined in section 617. Temple means place by whatever designation known, used as a place of public religious worship and dedicated to or for the benefit of or used as of right by the Hindu community or any section thereof as a place of public religious worship. The learned Advocate General contended that such concepts as Hindu charitable endowments and Hindu religious endowments were well known before these expressions were employed in Act 19 of 1951. They had been used in Madras Act 2nd of 1927, which was repealed and replaced by Act 19 of 1951. These expressions were used when the Limitation Act was amended in 1929 and when Articles 134A and 134B were introduced. Articles 134A and 134B referred to Hindu, Mohammedan, or Buddhist religious or charitable endowments. The Limitation Act did not define either what a Hindu or Mohammedan charitable endowment was, but the learned Advocate General contended the concept was clear enough. Under section 125(1)(a), if any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, a magistrate of the first class may, upon proof of such neglect of refusal, order such person to make a monthly allowance for the maintenance of his wife at such monthly rate not exceeding 500 rupees in the whole. Under explanation B, thereunder wife includes a woman who has been divorced by or has obtained a divorce from her husband and has no remarried. Under the explanation below, subsection 3 of section 125, if a husband had contracted marriage with another woman or keeps a mistress, it shall be considered to be a just ground for his wife's refusal to live with him. Keeping this in view, source is 3P Legal RHC, exercise number 54 और words है 760, speed 100.